Trump administration has had more federal lawsuits filed against it for its immigration policies than any other past administration. And finally, we'll discuss a bit on the options for H-1B visa applicants when their application is denied and it was a CAP subject application. So first today, Rahul, we have a new article on our website that has been published that has some pretty surprising numbers. It states that 50,000 Indian nationals would die waiting for their employment-based green card. First of all, how do we arrive at those numbers? Where
the 50,000 people who have already applied and are waiting for the green card are expected to die. This is from a Cato Institute, which have a good funding, and they do a lot of research before they write an article. And based on their study, we have given a link at our website at rnlawgroup.com. There is a lot of number of people who are waiting for the green card, and for the people who are already waiting, it may take more than 50 years for them to get the green card. They're also expecting, with the number of people who are waiting, approximately 50,000 people of Indian nationals are going to die while waiting for the green card application. So this is a study that was published by the Cato Institution. REDDY NEUMANN PC has published an article in February of 2018 that it's going to take 106 years for people to get a green card. Of course, we didn't take into account that people are going to die, and we didn't take into account that some of the kids who have become 21, who are US citizens, will file an application for the parents. The Cato Institution in August of 2018 came up with their own study taking into account the same things what we have used in February of 2018 of nobody is dying, and that the kids who are becoming 21 file for their parents, how long it's going to take. And they said it's not going to be 108 years. We were wrong by 42 years. They said that it's not going to be 108 years, it's going to be 150 years. However, in the month of October, the Cato Institution, they did account for a lot of other variables that will happen for the people who are in the line of getting the green card. And now they're saying that 50,000 people, 50,000 Indians are going to die while waiting in the line. That's a very staggering number. Unless the Senate 386 bill passes or anything related to the bills that are pending, where the Congress is going to work to cut down the time limit for the employment-based immigration, or if they take the per country limit off, like the bill which is there, Senate 386 bill, the HR bill which is already passed in the House, which is HR 1044, if any version of those bill is going to be passed, this may be prevented. The number of people who are going to die while waiting the green card will be definitely be completely prevented. One of the things that, you know, what a lot of the Indian community and Chinese community blame is that it's always that, okay, Senator Lee from Utah is going to pass the bill, want to pass the bill anonymously, but then there is an objection that came out from the Senator Rand Paul. A lot of our guys contacted Senator Rand Paul. He backed off with some compromise given by Senator Lee, where they included some of the healthcare workers to get a bypass. Then Senator from Georgia started objecting to that thing. And a lot of our guys contacted Senator from Georgia. He backed off without much compromise from Senator Lee. Now we have Senator Durbin, which is a Democrat, and he is putting a hold on this without allowing it to be passed anonymously. And a lot of the Indian people are just contacting Senator Durbin. He seems to be, he doesn't seem to be moving on it. He doesn't want to take that one off. My recommendation is that I want you guys to proceed not just for Democrats, but also you need to go and look into the Republicans. At this point of time, the Senate is controlled by the Republicans, not by the Democrats. Even if they can't pass this bill anonymously, the Senate has a complete authority to discuss this bill and pass it on. They have votes, sufficient votes to get this bill out. But Senator Mitch McConnell is not allowing a discussion on this one. So at this point of time, I would recommend the people who are waiting, especially the Indian nationals and Chinese nationals who have been waiting for a long period of time, to contact the senators to have this bill in open discussion, have it discussed and passed in the Senate. Yes, I want you to put a pressure on the Senator Durbin, but I also want you guys to put a pressure on the Republican senator, especially Senator Mitch McConnell, who has authority to bring this bill and vote it up and down. When you are contacting the senators, though, please don't tell that this bill is favoring Indians or Chinese nationals. This does not. The bill only puts them an equal range. Nobody is preferred in this bill. Everybody will be treated equally. I would say that I dream of a nation that treats immigrants by their characters, not by their birth. That's all. Please ask them that immigrants should be treated by their character, not based on the birth. So this particular bill is not favoring Indians or Chinese. It's just making the Senate 386, it's only putting everybody in equal line. No differentiation between the regular people and Indians and Chinese. Everybody will be the same lane. Now, on the H-1B cap that needs to be filed in April of 2020, Rebecca, you know, every time we file the H-1B in the first 5 working days of April of that particular year with the start date of October 1st. Now, what has changed right now with this administration?
Yeah, so almost exactly 1 year ago, the government proposed a very different system for conducting the yearly H-1B lottery, basically migrating most of the lottery part of the system to an electronic system where you would register online rather than sending in the full H-1B petition with all the supporting documents. The lottery would be conducted based on those electronic registrations, and then the selected applicants would be invited to submit an H-1B petition to DHS. So when it was first proposed last year, the government seemed to want to, they wanted to implement it in this past year, this past fiscal year's H-1B cap due to public feedback. They didn't do that since the feedback was primarily skepticism on whether the government could get that electronic system up and running in time for the April 2019 lottery. We haven't heard very much about the system since then, with the exception of the news that there will be a $10 registration fee for that electronic registration system. The director of USCIS, Ken Cuccinelli, did make some comments this week. No certainties, of course, but he has said that the electronic system is in the final testing stage, and that he is fairly confident that it will be up and operational for...
Did you say barely confident or fairly confident?
I believe he said fairly confident. That it would be operational early next year to be used for the fiscal year 2021 cap season. So still there aren't any certainties yet. The way that the final rule was issued in January 2019, it allows the government to postpone the implementation of the electronic system possibly for another year if the electronic system is not ready. So it still remains to be seen, although hopefully we will hear something in the next couple of months. If the system is going to go forward for next year's cap season, though, it seems likely that the registration period will be open most likely between January and March, and for that reason, we're urging people to start getting ready now towards the end of the year in case the electronic registration is open early next year. And then after that, the selected applicants will have a 90-day window to file the full H-1B petition.
So do you think so, Rebecca, that, so if I'm an applicant right now and I have a job offer, what do I need to do right now?
Start talking to your employer. Hopefully you have already begun those discussions with your employer if you're an F1 student working on OPT. If your employer has not filed H-1Bs before or are not familiar with the system, start talking to them, make them aware that that it will need to be done early next year. Even if they have, if your employer has filed H-1Bs in the past, they may not be aware that the system could be changing quite drastically this upcoming year. So start talking to them, make them aware that the timeline for actually submitting something online may be earlier than those last 2 weeks of March, the way it has historically been. Rahul, so we know that the Trump administration has been basically the most sued administration out of any presidential administration based on its
In the
immigration
immigration, yeah.
policies. Yeah, based on its immigration policies. Why do you think that is, and what do you foresee?
Well, the Trump administration wants to build a wall in the south of United States bordering Mexico. That's a visible wall he wants to build. But of course, as soon as he came into administration, he already had an invisible wall that will not allow any legal immigrants to come into the United States. He started with a travel ban. Then he started introducing the executive order to bar about 900,000 EADs that were given to the DACA kids. He also tried to put implementation with regards to the health insurance is required for the people who are coming into the United States. He started issuing on the public charge requirement for the immigrant visa people and non-immigrant visa people. So he started doing all these things without going to the Congress, without going to the Parliament. And that definitely people have no other way to go to the courts, and they started going to the courts for these things. Not only these things, Rebecca, we have seen that in the previous administration, if we are getting a denials of, let's say, for example, 1 or 2 a month, now we do see that 1 or 2 a day. That's a lot of denials coming on the H-1B. No law has changed, no regulation has been changed. The only regulation that has changed on the H-1B was with regards to the lottery system to have the master's people count first and then go to the bachelor's, which we all like that regulation. But other than that, no regulation has been changed. But if you look into the denial ratings, it has gone up very significantly. Now, H-4 EADs, H-4s approvals, the delays started mounting up. They used to approve those cases along with the H-1Bs. Now we don't have a premium processing for H-4. The delays are coming. That's one of the reasons why people are going to the courts. I mean, practically it has come to a solution where this administration doesn't want to approve anything. They want to delay. If not, they want to deny the cases. Of course, not all the cases can be denied. Not all the cases can be delayed. But they're doing as much as possible, and people are not finding anything else other than going to the courts. And the reason why they are going to the courts is that because they think very seriously that the immigration has violated the law. Now think of this thing: if the H-1B if we're getting H-1B denials of approximately, let's say, normally when a lawyer files, they make sure that everything is proper. We used to get a 2% denial ratings, and we are now getting more than 25 or 20% denial ratings, and that's a good example that the denials have gone more than 1,000, 10 times.
Mm-hmm.
So that's a good example why people are choosing to go to court to get their things approved. And the good part is that when we are going to the court, we're getting a positive result most of the time. Not all the times, but most of the time. So it's if the people are not willing to go to court, then either they have to leave the country because they're getting a denial. There's no option. We have seen that time and time again, the court giving judgment against, especially in the DACA cases, they put a hold on that one. On the public charge thing, they put a hold on that. Almost everything where you go to the court, we're getting a judgment in favor of the plaintiffs and against the USCIS. So today, Bloomberg has published an article on that. I would like you guys to read a detailed report on why people are going to the litigation. Having said that, Rebecca, that the H-1 denials have been going up after this administration. We have been in previous administration. I've been in Clinton administration. I've been in Bush administration as an immigration lawyer. I've been in Obama's administration. The denials are significant and they don't make sense. So what to do, especially if H-1B is denied in the cap subject H-1B, and if the H-1B is denied, what are the options that you offer?
Yeah, so the options, of course, are going to depend on the beneficiary, especially what their current status is, whether they still have, if they're here on F1 and are working under OPT, if they still have time under OPT. If you do, that is a preferable situation, although there isn't really a preferable denial situation. But if you do have that option, you can either refile in the next year's lottery, appeal, or do both. The disadvantage of the refile route is that obviously the pain of the extra pain added to a denial of a cap subject H-1B case is that if you refile, you need to go through the lottery again, because you were lucky enough to be chosen this year in the lottery, but it was denied, and so although the refile option is there, you have to hope that you will be lucky enough to get chosen again next year in the lottery. So that is an option, but it does require going through the lottery again. There's also the appeal option, filing with the Administrative Appeals Office. We've discussed the pros and cons of filing with the AAO on these videos in the past. It is definitely an option, although, as we've said, it is usually not very practical unless you already have some other non-immigrant status that allows you to remain here and continue working, because those AAO appeals take several months, usually 8 to 10 months or more, before there is a resolution from that option. So those have traditionally been the main options, refile or appeal, although as Rahul stated, we have, under the current atmosphere, been having to go to federal court more and more. So that is also something to consider. We've represented clients who have filed in federal court, not only for the H-4 EAD delay situations, but for H-1B cases, for the shortened denial notices, the shortened approval notices, which we have argued is an effective partial denial. It does appear that litigation is going to be a tool that more and more people will have to rely on, unfortunately, under the current adjudication trends.
Let's go to questions. One comment from Night Riders from YouTube. I don't like his comment, but he's telling that people have already died waiting for the green card, but I don't have any option. I acknowledge it, but there is not much we can be done. I do suggest everybody just don't be satisfied by calling the senator's office. Please write a detailed letter. We have given a draft at one of our business partners' blog in immigrationgirl.com. You can use the draft to send a letter to the senators and the congressmen. Just a lot of people ask, my senator is dead against, my senator is in favor. Well, if your senator is in favor, even if you are in Utah and your senator is Mike Lee, who is actually wanting this bill to be passed, send a letter to them. It feels that they are appreciated if you send a letter to him. If you send a letter to the people who are not favoring, they know that you're not, that you are opposing their stance on the Senate 386 bill. So please write a detailed letter. If possible, go meet with the staffers, explain your situation, how difficult it is. Each time when you get a H-1B approval, each time when you want to travel, each time when you want to get the driving license, there are situations where the H-4s are not approved and they need to drop their kids to the school. The moms can't drop the kids to their school. And when the extensions are pending, the driving license are not being issued. These are all the difficulties people will go through, and you're not being innovative because you're stuck with the immigration. One thing, you're listening to this video instead of doing your active work or enjoy your life. You're listening to this video. That's a good sign. Why you should not, you should try to strive to tell them, look, I'm watching these videos because I'm worried. What is going to happen? I want to get the green card. I want to get out of it. So please write a detailed letter. We have given that at immigrationgirl.com. You can search for it. The draft is very good. Please use that thing. Don't just be satisfied. Write a letter to your congressman. You can check your local congressman. Write a letter to 2 senators that you have at your state. Please, these are the 3 things that I strongly suggest that you do that. Tessie has this question. I work with an American private company with a senior info specialist. I'm planning to go to India. I'm planning to go to India. This is the first time. Well, we suggest, Tessie, that if you are planning to go for stamping, the first thing is that we want you to read the petition that has been filed. That's one thing that you need to do. That can be avoided. A lot of people will think that differently than what petition says. So just read the petition and be thorough with the petition, especially with the employer letter and the job duties. Look into those things. If you disagree with any of those things, we want you to contact your lawyer. we want you to contact your employer to speak with him. The other thing is that please make sure your social media is reflecting the H-1B petition. If your employer is ABC Consulting Inc. and you're working with Pepsi, do not put Pepsi as your employer, either in the LinkedIn or in a Facebook. Even if your Facebook is not visible, it is visible, guys. It is visible to the government. Now they're even asking you to provide the Facebook, LinkedIn, and other social profile that you have. So please make sure all these things are there.
Nancy from Facebook has a question. Her current H-1B is valid until next year, and she anticipates that she'll need to change to a different location but working for the same company. So she's asking, does she need to file a transfer application or an amendment petition? So in that case, Nancy, you would file, your company would file for you an amendment petition when it's a change in work location but with the same company. That company just needs to file an amendment petition for you. I would say based on your I-94 expiration date, they may want to consider filing a combined amendment plus extension application, because even if you didn't change work locations, you would have to file an extension next year anyway. So they can request in the same petition an amendment and extension at the same time and take care of both.
Rishi has this question from YouTube. If my H-1B is approved, with the transfer of H-1B is approved for less than 3 years, can I choose to stay with my existing company without moving, even though the transfer of H-1B has been approved? Rishi, absolutely you can stay with your existing company. Even if the H-1B is approved, transfer is approved, you can stick with your existing company, no problem with that at all. Question from YouTube from Sriharsha. Can I become a Canadian citizen and come back with a dual intent visa and apply for the green card? Yes, Sriharsha, you can, absolutely. Dual intent visas are mainly L1s and H1s. You can come back, and if you have a previous priority date, you can even port the date too, especially in EB2 and EB1, EB2 and EB3 and EB1. One thing, Sriharsha, that I want you to remind you is that if you are born in India, just because you become a Canadian national, for the green card purposes, you will always be Indian. You can never be a Canadian. For the non-immigrant visa purposes, you may be considered as a Canadian. You will be considered as a Canadian, but for the immigrant, for the green card purposes, you will be considered as Indian.
Okay, so Bahadev from Facebook has a question about his family traveling, his dependent family members. He is in H-1B status and has a transfer application that is currently pending and wants to know, is there any problem with his dependents traveling to India and coming back? There should not be any problem with that. They are able to travel in H-4 status as long as you are maintaining valid H-1B status, even if it is with a company that has the transfer pending for you. If they need to apply for the H-4 visa stamp at the consulate, just make sure they have the correct documents, including the H-1B approval from your previous company and the receipt notice from the company that is filing the transfer.
Radha Krishnan has this question from YouTube. He wants to travel, want to stay in India for 4 months and work in India for 4 months. Will that be an issue? Which salary can be issued? I'm not a tax expert, though. I will leave that to a CPA. You are an Indian national, based on my understanding. So if you're going and sitting down in India and working there in India for a period of 4 months, that's not a problem. However, Radhakrishnan, if your passport stamping is not being done, I don't want you to go for passport stamping at the end of the 4 months. I would like you to go to the passport stamping as soon as you go, rather than wait for 4 months and get to the stamping. It's tactically very good for you to get the stamping done earlier.
Okay. Manish has a question about his wife. She's on an H-4 EAD and may be going on unpaid leave soon. And I think your question is whether her going on leave is going to affect the EAD and the EAD renewal that she's planning to file concurrently with your H-1B extension. So if I'm understanding that question correctly, her going on leave is not going to affect the EAD renewal or the H-4 at all. So the EAD, the employment authorization document, is a work permit. It allows the holder to work at basically in any capacity for any company, however much they want, even if that is not at all. So whether the company considers her a continuing employee based on her requested leave, that won't affect her being able to get the EAD renewal at all.
Nickel from YouTube has this question. His parent has filed a F-2B, unmarried son, in 2012. He's now married and his priority date is current. Is the petition still valid? Assuming that your marriage happened before your parent has become a US citizen, because you haven't given full information, assuming that your parent has not become a US citizen before you got married, that petition is invalid, completely invalid, and you cannot get the green card based on that petition. From the YouTube, I have this question from Shushil. I am on a part-time H-1B filed an in-house project. Right now, I'm working at an end client with a different location. Amendment was never been filed. There was no amendment filed from part-time to full-time, and also from the different from the in-house to the end client at a different location. Sushil, you definitely are out of status. You need to contact a lawyer immediately, because if it's an in-house, you are moved to a different location with a different employer, you are supposed to file an amendment. You moved from part-time to full-time, you are supposed to file an amendment. That's a violation. You're violating the status.
Jithan was asking about going for visa stamping in Calcutta if his last visa stamp was issued in Chennai, whether he can go to a different consular post to apply for this next visa stamp. And the answer is yes. You do not have to go back to the same consular post in order to renew your visa. He also asked about the Dropbox option. Yes, you can apply at the Dropbox if you meet the requirements that are on the consulate's website for qualifying for the Dropbox. You don't have to apply in the same consular post as previously, as long as you meet all the other eligibility requirements for the Dropbox.
Srinivas has this question. It's a very, I need some help from you on this one, Rebecca. That he filed EB-1 extraordinary, and his lawyer is telling to not to convert into premium processing because it tends to get an RFE.
For an O1?
No, EB-1, extraordinary.
Okay.
We don't believe that just because you filed in premium processing, you're getting this RFE. You're just getting it because you're getting it earlier than later. EB-1 extraordinary ability has a very good chances of getting an RFE, irrespective of whether you would go in a premium processing or normal processing. Very good chances. I mean, we can't see. I mean, if you have an Oscar or Nobel or something nearby, you may not get the, but it's very tough thing to get the approval. We are tending to get a lot of RFEs on it, so you will get an, you have good chance of getting, it has nothing to do with the premium processing though.
Right.
It just gets you earlier. I would rather get an RFE. I would rather even get a denial if I have to. And file, you can still file one more EB-1 if you want to. But I don't want to sit on that for 2 years and get a denial. You're going to lose a priority date here, because priority date is also important for EB-1. Previously, priority date used to be current. So I would like to get the decision as fast as possible. Unless you have some things where it will take a lot of time to collect the documents and put it together, I would do the premium processing.
Hamath is asking, will it be any faster to get the green card for Indian nationals if the place of birth is another country, but you still have an Indian passport? So I don't know, Rahul, if you answered this earlier, but I think Rahul mentioned earlier that for purposes of the green card for the immigrant visa, the chargeability is based on country of birth. Even if you have been naturalized or received citizenship in 2 or 3 other countries since then, you will always be calculated based on the country of birth under our current immigration system. I mean, that's the exact reason why we're...
Right. But what normally is, Rebecca, is that some of these people were living in Middle East.
Yeah.
So their parents and their kids are living, the kids are living in Middle East. They're born in the Middle East, and they don't give citizenship in Middle East. They were always been an Indian citizen. Yes, you will not be considered an Indian citizen for the purpose of the green card, even though from the birth to right now, you're still holding Indian citizenship because you're born in United Arab Emirates or Saudi or whichever country you might be, you will be considered as that country's citizen only for the purpose of the green card. So yes, you are lucky in there. You will be able to cut the line.
Yeah, it is literally based on geographic location of birth.
So as I was pointing out, I believe in a system where USA will grant immigrant visas based on the character, not by the birth. But at this point of time, they are not looking into the characters, they are looking into the birth. So in your case, it was fortunate for you to have been born in a different country. You will fit into you will fit into the other country quota, sir.
Raghavendra is asking if an amendment needs to be filed if his new work location with the same employer is within a 10-mile radius. Most likely not. The work location change requiring an amendment is typically where the work location moves to a location that is outside the Metropolitan Statistical Area, the MSA, usually outside of the city or kind of the county of the previous work location in the previously approved H-1B application. So if your work location is changing literally 10 miles down the road, most likely you do not need to have an amendment filed. Just to make sure, you should check with your immigration attorney who filed the previous application so they can look it up, make sure it is within the same MSA.
Karthik has questioned that his H-1B has been rejected because of the employer-employee relationship. Does he have a chance of litigating? What are the probabilities of litigating? I think so, Karthik, you need to evaluate by a lawyer the litigation. Your chances will be quite higher litigating the case in the court. Our office, which never used to be in litigation, we are in business from past 22 years, but we're only in litigation from past 4 to 5 months. We strongly recommend to contact our office or anybody office who's been litigating. We hired Jonathan Waston, who used to work for the other side of the immigration for 8 years, and he's working for REDDY NEUMANN PC right now. And you can make an appointment with him. I strongly recommend to make an appointment with Stephen Brown in our office to be considered for the litigation. I have this question for you, Rebecca. Does this new electronic system of the lottery quota that we have, will the applicants come to know sooner that their application has been accepted or denied?
So the electronic system doesn't appear to affect the processing time of the petitions once they're actually filed.
But when would I come to know that my thing is
whether you are chosen in the lottery?
Right.
Hopefully faster. I can only imagine it will be faster than our current system, which relies on emails from the premium processing unit if we are lucky enough to have premium processing available, or receipt notices sent through the mail. As we mentioned earlier, there just aren't that many specifics that have been announced by the government yet. No specific timelines just yet, except for a kind of a bare outline that was included in the proposed regulation last year. But it does appear that they would notify the petitioners electronically, I would imagine, to notify them of the selection in the lottery so that they can prepare the petitions to be filed within that 90-day time period.
We will getting the new regulations hopefully so by end of this week. Maybe if you are going to come for our next week, Tuesday, we may be able to guide you more on the lottery system, because the final details are, the devil is in the details. We will get the devil by the end of this week by the USCIS. Hopefully, that's what we have been told. But if you keep following us, we will give you more idea on it. I need some second opinion on this. This is from Sharad from YouTube. He's asking the question that companies are refusing to interview people from India who are on H-1B. They were wanting to have a green card holders or United States citizenship. Is this violating the civil rights? I don't think so. It's violating the civil rights. Absolutely not. I don't think so. Do you agree with me? I mean, employers wanting to hire only GCs and the US citizens, and they don't want to interview the H-1B people.
I don't think that is a violation of any
it's not a violation.
laws.
If you do not have a work permit, where if you are seeking the employer to have a sponsorship, that definitely is an extra step they don't have to go through. They are under no obligation. They are not violating any Civil Rights Act by not considering the H-1B people. The U.S. workers definition does not include the H-1B as the U.S. workers because the employers have to file an application with the USCIS to get it approved. Unfortunately, they could discriminate based on that you are on H-1B.
Tessie is asking if security clearance is needed for information security or specialist jobs. And I think part of your question earlier, Tessie, was in relation to applying for the visa stamp at the U.S. consulate. So a lot of that depends on the specifics of the job. The SOC code that I think you mentioned, there isn't any rule that that entire SOC code in general needs to have some particular clearance before you can apply for the visa stamp at the consulate. There is one question on the I-129 form, which if it's answered a certain way, you should check your I-129 form to see if that question is answered concerning particular technology that you may be handling. But if you are, you should already know. I would check with your immigration attorney to see if that's required. Having said that, I would say at the consulates, we have seen cases where applicants who are working with what appears to be very highly sensitive material that requires a lot of security and that sort of thing, you might expect to have delays in your visa processing. I wouldn't be surprised if you received a 221G or administrative processing, or if your case was put on hold, just for the consulate to look into it further. So you might expect delays at the consulate, but it's not, that SOC code wouldn't be a reason for a visa to be denied outright.
Normally, the employer or the end client would have the information with regards to your particular position would require a security clearance are there. And the security clearances are different, there are like many different categories.
Right.
We may not be the best guys to advise on that. Can the H-1B guys go through the security clearance? Up to a certain level, the answer is yes. For example, if you're going to go to do a job with Lockheed Martin and a very sensitive material, they may even want people to be US citizens. I have seen those kind of restrictions also in the security clearance. But there are some entry-level things where people can do it. The security clearance is required for them. And I've seen the FBI going and asking all the ex-employers. That normally happens. Even some of our ex-lawyers who went and joined the USCIS and also the other agencies in the government, they got their security clearance, and the officers, FBI officers, came to us and asked questions. We did answer the questions. They are working at high-level jobs, and some of them are, and that happens. I mean, even if the H-1Bs, have seen them, if you work in a military establishment or something like that, they require you to go to a certain security clearance. But to say that only a particular SOC code requires, I don't agree with that on that. It requires more on the job. Amit Kumar has this question from YouTube. My child is born in China. Can the parents apply with a Chinese priority date? Well, Chinese priority date is not that great anyway, but the child being born will not be applicable for the cross-country chargeability. However, Amit, though, if your wife is born in China, then even though you are the main applicant, then you can go with the cross-country chargeability. But not when the kid is born. Only the spouse. If the spouse is born in a different country, you can still go with the spouse country even though your spouse is not main applicant. It's called cross-country chargeability. So we can pick and choose which one we want to go. So based on that, you can. But unfortunately, your child is born in China, you can't.
Vijay has a question about the Texas Service Center backdating H-4 processing times from June 2019 to January 2019. And if that's common, and if it will take an additional 4 or 5 months now to get that H-4 application processed. Unfortunately, processing times increasing has been a trend under this current administration. It's It's why we have had to take the extraordinary measure of going to federal court for the delay in a lot of these H-4 cases in particular. And USCIS can just update its own website concerning its processing time, and then not accept any follow-up inquiries, not accept any expedite requests, or basically disregard any expedite requests on the basis that it's within normal processing times, according to what they call normal, as stated on their website for that particular service center. So our office, like we've said before, has tried every other way this year to expedite I-539 processing, and the only effective way that we've found is going to federal court to require USCIS to adjudicate these applications within a reasonable time frame.
Got the question. Amigo has this question from YouTube. We help people out in Canadian immigration? Unfortunately, REDDY NEUMANN PC does not do Canadian immigration. Having been said though, I'd suggest you that if you were in USA, if I were you guys, I'm going to apply for the Canadian immigration, not through REDDY NEUMANN PC because we don't do it. But if I were you, coming from the background where I come from, instead of waiting here for whatever long, that story changes every time with REDDY NEUMANN PC. One time they said 82 years, one time they said 180 years, then they are saying 150 years, and God knows how long it's going to take. I would still go for the Canadian immigration, not with REDDY NEUMANN PC, but with any competent lawyers, yes. Another question that came from Leif. Is the EAD delay more than 6 months? Is it only for H-4 EADs or even for E-3 EADs? Every EAD, H-4s, L-2 EADs, E-3 EADs, adjustment of status EADs, everything is taking more than 6 months. Unless you're willing to litigate, this is going on. The administration is hell-bent on delaying everything as much as possible. In the recent hearing, they were not apologetic with regards to the delay. Normally, when the administration goes in front of the Congress and the Congress asks the question, what's going on their delay, the administration will always come up with this and that. We are trying to work on it. This administration said, no, we're not going to expedite it. It is expected that the delays are going to go more longer. What a statement they're making. They're not working hard to cut down the timing. Now, however, the Congress required them to adjudicate these cases in 30 days. But they're not adjudicating the cases in 30 days. That's the reason why we are litigating. Another question came from YouTube is on the August 25th litigation that we do file every 2 weeks litigation. On August 25th litigation, have we seen any approvals that the cases that we filed? The answer to the question is no, not yet. We have not seen any approvals from August 25th litigation as of now.
Hari from Facebook is asking if he travels to India, can he apply the Dropbox, or does he need to go in person if his job has changed with the same company, changing his role to that of a project manager? So actually, before you think about which option to go for at the consulate, Hari, I would discuss with your company and your immigration attorney about whether an amendment application needs to be filed first with USCIS. Evaluate how much your role, your salary, your responsibilities have changed through your promotion compared to the already approved H-1B application. The rules for when an amendment application needs to be filed with USCIS does not apply only to a change in work location. So technically, an amendment petition needs to be filed when there has been a material change in the terms of employment compared to what was listed in the already approved H-1B petition. So if your salary has increased significantly, your job responsibilities have changed significantly through your promotion to the project manager role, you may need to have an H-1B amendment application filed with USCIS first in order to make sure you're maintaining your status here. Then once you've determined that, if the amendment petition is approved and you meet the qualifications for the Dropbox eligibility, you can still apply at the Dropbox when you do travel, but I would look into the amendment requirement first.
Sriram from YouTube has this question. Is there a possibility that they will move the diversity lottery to the highly skilled? Is there any proposal to move that? Sriram, there are proposals, though, but I don't want you to deviate from the Senate 386 bill. At this point of time, we have a good chance of getting the Senate 386. I'm not telling how much chance, but it has the most best chance under your circumstances. I've been an immigration lawyer. I've gone through a lot of these legislations for past 25 years. I've been an immigrant. I'm telling you that don't get deviated because they are telling, okay, we have this proposals, we have this proposal. Yes, there are 100 different proposals. We have been seeing it. Obama tried to pass a law to have more immigration to the employment. He couldn't. Bush tried to do it. He couldn't. Clinton tried to do it. He couldn't. Now, Trump doesn't want any more immigration. Now, is he going to agree with all other proposals? I don't think so. The Senate 386 bill has a good chance of passing for only one reason. It's not increasing the number of green cards. That's the reason we think so that Trump is going to sign the petition. So please focus on Senate 386 bill. The bill is already passed in the House, which is HR 1044. So don't deviate from the main bill and try to say that is better, this is better, this is better. We are going to end up with nothing. So focus on Senate 386 bill and just don't focus on Senator Durbin. Try to focus on the Mitch McConnell for the Senate Majority Leader for the Republican Party too.
Bhaskar is asking, what is the reason for a lot of the H-1B rejections? Is it related to educational qualifications, and can work experience be taken into account? So there are many reasons for the increase in H-1B denials. We see USCIS changing their standards on a number of issues, including what qualifies now as a specialty occupation, the requirements for documenting employer-employee relationship, and, as you mentioned, Bhaskar, educational qualifications, the beneficiary's qualifications. The strangest thing is we see beneficiary qualification RFEs and denials sometimes for H-1B beneficiaries who have had a number of H-1B applications already approved for them in the past with the same petitioner in the same position. A lot of these RFEs and denials occur when the beneficiary has a degree in engineering but is working in an IT position. And it does seem odd that this person has an electronics and communications engineering degree, for example, and it qualified for an H-1B visa 3-6 years ago, and all of a sudden USCIS is saying it doesn't. That's just the changing standards within USCIS under the current administration. Obviously, the beneficiary himself or herself is not more or less qualified than they were when the H-1B application was approved previously, but it's just a function of the current atmosphere that we're in. As far as what we have done to overcome those RFEs, work experience is something that definitely helps in that case. If a beneficiary has at least 3 years of work experience in the relevant industry, for example, in combination with, for example, an electronics degree or an electrical engineering degree, we've been able to get evaluations that take that experience into account and equate it to the equivalent of a degree in information systems or something similar for an IT position, for example. So using work experience is definitely one strategy in overcoming those qualifications RFEs.
Well, the Keep On Traveling has a good question from YouTube. He's asking the question, if we call the senator, will the senator listen to us? Yes, they will put a tick mark. Are you in favor of Senate 386 bill or opposite to Senate 386 bill? Well, let me tell you one thing. There are more immigrant haters that are calling for this bill not to be passed. By calling them, you will do some favor, but I think so that the best way is to write a letter, explain to them. The haters can't explain what's happening with their families. They just hate you. All they're telling, we hate you. But you can write a letter to them. look, my driving license is a problem. My every H-1B extension is a problem. My time that I spent with this Reddy and Neumann PC on this YouTube is a problem. My kids are going to school. How is it going to work out when I don't get the driving license? Every time I have to travel to my country, I need to check to make sure everything is there. I have to get the visa there. If I want to do a business, if I want to invest in some more homes that I want to buy, if I want to do any side business, I can't do it. If I want to open another business, I can't do it. There are a lot of things that as a green card holder that you can do, you cannot do it. Please write and explain that to Senator. Then they will understand it much carefully. You just say, I am in favor of Senate 386 bill, and you just leave. That's not a right way of doing. Believe me, there are more haters. They won't tell all the things why they hate you. All they say that we are opposed to Senate 386 bill, and they just keep the phone off. So I want you to not just call, write to the senators, write to the congressmen, explain them what are the difficulties. That helps them when they look into it, when the staffers read into those things, look what kind of difficulties they are facing, they will understand it much better. They are humans, so they will fall into that. I want you to write a letter and give them the detailed discrimination, detailed description on what is going on, what discrimination is going on YouTube. Write it to them, and then if possible with a group of people, try to go, okay, we're 10 people. Take your kids with the senator's office. I mean, take your wife and don't go, We have seen, some of these things, the immigrants coming, only males are going, no females. That doesn't sound good. And I want you to take your wife, your kids, go there. It's going to sound much better to you in representing. Just don't be satisfied by calling them, guys.
Alan has a question about applying for the H-1B and H-4 visa stamps at the consulate with him and his wife, and the timing of it. He is eligible for the drop box. She has to attend the in-person interview, and he wants to know whether his visa stamp needs to be issued before she can attend the in-person interview, and the answer is no. So if you are able to schedule it that way, that's fine, but it's definitely not required. It's not required that the H-1B visa holder's passport already be stamped in order for the H-4 dependent spouse to apply for and receive the H-4 visa. Even if you were not traveling together, if you stayed in the US, as long as you were maintaining H-1B status, your wife could still apply for the H-4 visa. She just needs to bring your H-1B approval notice, the I-797 approval notice, and proof of the marriage certificate, and other documents related to that.
I just want to clarify, Sujana's, on the October 25th litigation, we have not seen any approvals yet. We don't have any litigation filed on or exact August 25th. I only mentioned about October 25th, we have not seen any approval yet. I want to address this I-140 application, I-140 that came out. I also got a request from email from having to address the I-140. If the I-140 is approved, and approved for more than 180 days. If the employee moves to a different company, can he use that I-140 for the further extension, not for the first transfer, but also further extensions?
Yes. So if an I-140 petition remains approved for at least 180 days, the benefits that the beneficiary receives from that I-140 are that he can use that approval in order to apply for extensions of H-1B status beyond the 6th year, basically indefinitely with any other company. If he moves to company BCD, you can always use that I-140 approval as long as it remained approved for at least 180 days. You can also retain the priority date that was issued under that approved I-140 petition, and that is even if the I-140 petitioner eventually withdraws the I-140 approval after you leave the company.
So H-4 EAD, even if the I-140 has been withdrawn after 180 days, the H-4 EADs can also continue, right, even if you move to company B, company C, company D, I-140 EAD, the EADs for the H-4 EADs are still there. And also you can put the date at any point of time in your life. I have had situations where people went into India, the I-140 has not been withdrawn. They come back again and then they put the date. For example, if your I-140 is approved in 2017, now you leave the country and you go to India, you can always come back on a H-1B at any point of time in your life without subject to cap. because you have your I-140 approved, even though you use a 6 years H-1B, even if your I-140 has been withdrawn, subject to the condition it's been withdrawn after 180 days. You can go to India for 10 years, you can come back here on H-1B, absolutely no problem, using the same I-140, and you will not be subject to cap. And once you come back, you can port the date. That is the only thing that you cannot do with the withdrawn I-140 is if and when the priority date becomes current. And according to this video, it's not becoming current unless there is a change in the law. If when and it becomes a current though, you cannot file the adjustment of status with your company B, the different company that you are working with. You can't file the adjustment of status. That's the only drawback that you have. Otherwise, you can port the date, H-4 EADs, H-1B extensions, you can go back to India, come back in H-1B. The magic thing that you need to remember, the magic word is that, was the I-140 approved for more than 180 days? Once that is approved, then it is tattooed to your face, it is going to be with you, except for the purpose of the green card, where you need to file the adjustment of status. Then at that point of time, you would require another labor and other I-140. You can still port the date.
Sharmila has a question about, so it sounds like she just got admitted to a school and wants to know if it's preferable to use the H-4 EAD that she already has, or to apply for the F-1 change of status, given the uncertainty of the H-4 EAD in the future. Yeah, so the H-4 EAD future is somewhat uncertain. Obviously, the current administration is trying to eliminate the H-4 EAD, although it will be much easier to use it if it is still available when you graduate. So yeah, it may be advisable to start the F-1 change of status process now. I would say it'll depend on your program end date, how long your program is expected to be. If you're going into a bachelor's program, that will take 4 years. It may not be necessary to start the F-1 process now. If it's a master's program that will take 2 years, then yeah, it may be prudent to start that process now, because as you're probably aware, the I-539 change of status application to change your status from H-4 to F-1 could take 12 to 18 months, possibly longer if processing times continue to increase. I would definitely consult with an immigration attorney if you do decide to use the I-539 to change your status from H-4 to F-1, because there are additional B-2 bridge applications that may need to be filed in order to maintain your status due to the length of time it's taking to get F-1 applications adjudicated.
Before we close down, I have two main things that I want to answer. One is this, Sri Harshadaram from YouTube has this question that his consultancy is ready to file a L1B, L1A and EB1A. Is it a good idea to go to India and come back after 1 year and file an EB1 visa? Sri Harsha, it's not that easy to file an EB1A, EB1C application. And it's not that easy to get an L1A approved though. A lot of people are under the assumption that the L1A is easier thing, just go there, work for 1 year, and then you will be considered as a multinational executive. No, it's not that easy. It's very complicated. Now, having said that, if somebody wants to go to Canada, become a Canadian citizen and want to come back on a TN, I would say, yeah, TN is not that complicated, considering the situation that what we normally look into. But when you are changing your life and you're moving to India for a 1 year period, and you're thinking that L1A is approved, please consult a lawyer before you go. There are a lot of things. If it's just a small consultancy organization, you cannot. If it's a big organization, there's another problem there. They promise things, okay, I will do it. Your manager will promise everything, but the HR says no. So there are a lot of complications that will arise. It's not easy to just get an L1A or EB1C application approved. So please consult your lawyer before you do. Before closing, I want to address Sri Krishna's thing. It's a good thing that he brought it up in the YouTube that what will, if the government changes in the next election? Sri Krishna, I've been an immigration lawyer from Clinton's time to Trump's time. Clinton tried to change the immigration. He didn't. He was definitely a favorable guy. And Bush actually, normally the Republican parties, and I'm not getting into politics, but the Republican parties may or may not be that favorable in the overall of the immigration. In the employment-based immigration, they're different. Overhauling the immigration. But Bush, though, was a real favorite guy in getting the overall of the immigration. He tried to push as much as possible. He couldn't get it done. And then we have Obama. He was there for 8 years. He tried to get it done. He couldn't get it done. Now we have Trump administration, and you're telling that, okay, now the election changes, something comes up. Don't wait. Right now, Senate 386 bill is not in the headlines in most of the news. They don't consider this as an overall of the immigration. They consider it as a small bill. Hey, we don't even know what this is, what's going on here. They're not increasing the number of green cards. They're not doing anything. Oh, just per country limit. Let's take this off. So most of them are under that. And it is, what I said. There's nothing there. They're not increasing the numbers. They are just telling that they'll stop discriminating. They're going to treat the immigrants based on the character, not by their birth. That's all. They're not increasing the numbers. So, Sri Krishna, it will be good that if you focus on the Senate 386 bill, rather than thinking or dreaming on, okay, something is going to come. Clinton didn't do it, Bush didn't do it, Obama didn't do it. You think so the future president may be able to do it? Because it's not just the presidents. To change the overall of the immigration, we need the Congress. And the Congress is deadlocked from past 24 years. Don't expect anything to come out miracles there. So this is a small bill. It may be passed. It has a good chance. It's a good fight for you guys to go. Anything else, Rebecca?
Nope.
Well, thank you guys for tuning in. If you want to, we do have a daily conference call, or you can make an appointment with me or any of my colleagues at rnlawgroup.com. Don't forget to subscribe to our news at RN Law Group. And thank you, Rebecca, for coming and joining.
Thank you.
Thank you, everybody.